Hello once again. We're just going to do a screen share of commercial liens and the basic maximums of commercial liens. So I'm just going to share a video with you here today, and I might stop to take notes every once in a while, but yeah, should be good. So enjoy.
Type it so that you're not just filling in your name in a bunch of places and sending it out in a Word document. But if you want to get the Word documents for a lot of tonight's documents, and whether or not it's for the documents or not, but just to get a second witness to this type of information, I highly recommend Winston Shrout has a single DVD. It's only about an hour and a half long, comes with all the documents and everything, and it's called Commercial Lien, a Firm Foundation. Okay, so for those of you who are looking to actually execute these, definitely get that as supporting material for what we're going to be discussing tonight. And in the documents, there's a 82-page document. I have it here, called Commercial Liens. What is it called? Commercial Liens, a Most Potent Weapon. I highly recommend you read that document front to back. It'll give you an understanding of a lot of the principles and concepts that are necessary for you to have an understanding of before you do any of these things. We only have a couple hours here tonight, and we only have one more class in addition to this one. So in reality, I cannot give you what you need before you start executing these things, because they are such powerful tools. These are you've heard about people seizing bonds and getting $1 million, not only judgments, but multi-million-dollar claims and enforcement and liquidations on bonds and officers and things like that. This is the method they most likely use. If you've heard about Winston Shrout's story about he got pulled over by a sheriff, they gave him a bunch of crap. He turned around, executed a commercial lien, just like the one you have got, that you get a copy of tonight, that he liquidated for about $3.8 million against the sheriff, against the sheriff's department, or I think it was maybe the sheriff and the mayor or something of the city. Or a marshal, something like that. I forget. Yeah, so they're very effective, very powerful. They require an understanding of due process. Now, remember, last week we talked about doing our due process with our contracts that we're establishing with different parties, whether it's A for V or anything else. That is supporting material for a commercial lien. But a commercial lien has its own due process, okay? I'll go through this first example real quick. Might actually read through it, but I want to get the pieces so that you understand how this particular lien, how it was established, so that you can, again, this is not the only way to do it. And in fact, I included a couple of examples here. And I included, actually, you'll also see some different forms of, other than what I've provided in the past, of certificates of non-response, notices of fault, opportunity to cure, notices of default, completely different than what you've seen. Okay, so just to show you, it's not the form that you've been given, it's the substance. Okay, now you'll see that there are some common links, some common threads that tie together the processes we've discussed in the past and the processes that are included with tonight's material. That would be what I call the requisite form. There are just certain elements, like an affidavit, there must be some kind of an oath verification certification on it. That's part of the form, but the substance is the content within the affidavit. So again, these are more about substance than form, but you'll see a couple different examples how you can come to establishing a lien. Now, a lien, what creates a lien right? Anyone? What creates a lien right? Okay, a liability for something, an interest in something. Would a breach of contract create a lien right? Once you have a lien right, what would we call execution on that lien on the surety? If we were going to execute on the surety or a liquidation or levy. Okay, you've heard of levies and liens, right? Well, you have a lien right, and when you have the lien right, executing that lien right on the surety would be a levy. Okay? So in this particular process, the first step was an affidavit of truth. Okay? Sent as a presentment through a notary. Now again, for those of you who are in other countries where getting notary presentment done is nearly impossible, or in different parts of this country where you don't have access to a notary who does presentment, it is not a necessity. In fact, in tonight's documents, you'll see a couple of supplemental affidavits of non-response and affidavits of service, whereby rather than a notary doing the presentments and certifications, a witness, which could be a friend of yours, could be a relative, could be someone, typically you want it to be someone who doesn't actually have an interest in your process. If they're going to benefit from your process, not a good idea to use that person as the witness. Okay? So anyone, it can be anyone. And I would suggest when you do use witnesses that if it's an affidavit, like an affidavit of non-response or an affidavit of service, that you have that affidavit with a jurat on it, because any notary will do a jurat. And once you have a jurat on that certification or that affidavit, you can now apostille or certify that, authenticate it for use in foreign jurisdictions. Okay, so anything with a seal on it becomes a self-authenticating document. So if you can't get a notary to make the presentment, have a witness the contents of the mailing and sign their affidavit in front of a notary, or have a witness be your responder or your acceptor of your process, whereby they can certify the non-response of the other party and have that certification notarized or jurated. Okay? So this affidavit of truth, in this particular case, what he's doing is establishing the facts of the case. Okay? It's not a negative averment or anything like that. It's basically, I, John Smith, depose and say the following. He basically goes through the technicalities of what happened on the particular night in question. Actually, this looks like it's the one that he did on the officer. On August 3rd, 2000, at about 6:05 p.m., was traveling on Highway 91 at approximate speed of 45 miles per hour. I noticed a white car approaching from the rear, traveling at a speed. It's basically a narrative of everything that happened that night. Okay? So basically, what he's doing is presenting this affidavit of truth on the party he wishes to execute his lien on as step one, giving them an opportunity to rebut it. In commerce, an unrebutted affidavit is truth. Okay? So, he's giving him an opportunity to rebut the facts of the matter. Step one. Of course, he sends this along with a proof of mailing and contents mailed. Okay, this particular one is from a notary, doesn't have to be. And then, as a follow-up to this, I'm sure you give them 10 days. As a follow-up, he's got the certificate of non-response. Now, a lot of you have seen the certificates of non-response that I use. Look at how simple this one is. That's all it needs. I, so-and-so, a notary public residing in such and such a county, such and such a state, do say that as of such and such a date, that there has not been any written response to the affidavit of truth by John Smith nor Bill Brown, or by John Smith nor Bill Brown sent certified mail return receipt to me. That's it. Certification, non-response. See how simple it can be. So, once the 10 days have transpired, you've now got facts established. Now, this particular step one could be equated to your three-step process that you did with, let's say, a conditional acceptance, whereby your conditional acceptance included a what? An affidavit. Unrebutted is established facts. Then you gave them an opportunity to cure, which again probably had some kind of statement of facts in it. Unrebutted. So you've got two statement of facts, certifications of non-response to both of these. That could serve as your step one on this commercial lien process, whereby you've given them everything up front, all the facts, opportunity to cure, their default. So now, because really when you see what these liens consist of, this is straight to enforcement. There's very little you're going to have to do after you've perfected this to liquidate or to get your remedy. So if you've been damaged, for instance, this credit card company not removing the marks from the credit like they said, and they never verified or validated the debt with your 54 questionnaire, and so have defaulted on the facts, you could, again, you've got your facts established with your presentments to the credit card company. It doesn't mean you couldn't do an affidavit of truth just to kind of sum up everything that you already did and give them an opportunity to rebut it all in one document. So here comes since we are making demand and we are creating a security, that's what this is. This document is a security as defined under 15 USC, okay? This security, because of the nature of it, you are only going to be serving copies of your documents on the respondent. You keep your original affidavit of truth. And of course, the original proof of contents mailed and an original certificate of non-response. You don't ever have to send them a certificate of non-response. That's for your evidence that goes along with your lien document. Okay. Most important document in a commercial lien. Affidavit of Obligation. This one's entitled Affidavit of Obligation Commercial Lien. Notice this little box in the upper right-hand corner. It is called a tracer flag. In order for this to be a security, it must have this flag on it from the beginning. So it's not something you add to it after you've already done the commercial lien process. If this tracer flag is not on here from the presentment of the document, it is not a security. Tracer flag reads a security, in parentheses 15 USC, a US SEC tracer flag, not a point of law. Affidavit of Obligation, commercial lien. Okay? Now, first page and a half, we're establishing the laws of this contract. Remember how important it was to establish the law? We just basically list a bunch of commercial maxims. Okay, anyone know what a maxim of law is? Okay, so maxims. I'm going to go through these because I think they're great to know, because we're establishing these as the law in our process, but these are maxims of commercial law. These are givens. But because we're not relying on any outside law source for our lien, this is coming from the private, we're going to put the maxims in here which are relevant for our process. All men and women know that the foundation of law and commerce exists in telling of the truth, the whole truth, and nothing but the truth. Truth, as a valid statement of reality, is sovereign in commerce. An unrebutted affidavit stands as truth in commerce. An unrebutted affidavit is acted upon as the judgment in commerce. Guaranteed, all men shall have a remedy by the due course of law. If a remedy does not exist, or if the existing remedy has been subverted, then one may create a remedy for themselves and endow it with the credibility by expressing it in their affidavit. Ignorance of the law might be an excuse, but it is not a valid reason for the commission of a crime when the law is easily and readily available. To anyone making reasonable effort to study the law. All corporate government is based upon commercial affidavits, commercial contracts, commercial liens, and commercial distresses. Hence, governments cannot exercise the power to expunge commercial processes. Do you know why people are so afraid of commercial liens? Because you're the only one who can do anything about it. Nobody can remove this once you've put it into place. There ain't a judge in the land, the president himself, UN secretaries, leaders of the world courts, Nobody but you can remove this lien once you've established it. The legitimate political power of a corporate entity is absolutely dependent upon its possession of commercial bonds against public hazard. Because no bond means no responsibility. Means no power of official signature, means no real corporate political power, means no privilege to operate statutes as the corporate vehicle. That's important because one of the sections of this particular document is surety. The corporate legal power is secondary to commercial guarantors. Case law is not a responsible substitute for a bond. Municipal corp. That's important because one of the sections of this particular document is surety. The corporate legal power is secondary to commercial guarantors. Case law is not a responsible substitute for a bond. Municipal corporations, which include cities, counties, states, and national governments, have no commercial reality without bonding of the entity. Its vehicles, in parentheses, statutes, and its effects, in parentheses, the execution of its rulings. In commerce, it is a felony for the officer of a political public office to not receive and report a claim to its bonding company, and it is a felony for the agent of a bonding company to not pay the claim. If a bonding company does not get a malfeasant public official prosecuted for criminal malpractice within 60 days, then it must pay the full face value of a defaulted lien process at 90 days. Meaning, 30 days, this is matured, okay? At 90 days, it's an account receivable, and anyone can collect on it. You can assign it, and whoever you assign it to can collect full face value of it. If the bonding, and the only way that they couldn't collect on the actual bonding company was if the bonding company goes after the public officer for criminal charges. That's the only time the bonding company would not be responsible. And you'll see, even if they go criminal charges, we've left in here a little clause about not only is your bond the surety, it's your private property. So if the bonding company does charge them criminally, we've got their private property as surety as well. Except for a jury, it is also a fatal offense for any person, even a judge, to impair or to expunge without a counter affidavit, any affidavit or any commercial process based on an affidavit. Judicial, non-jury commercial judgments and orders originate from a limited liability entity called a municipal corporation, hence must be reinforced by a commercial affidavit and a commercial liability bond. A foreclosure by a summary judgment, non-jury, without a commercial bond is a violation of commercial law. Governments cannot make unbounded rulings or statutes which control commerce, free enterprise citizens, or sole proprietorships without suspending commerce by a general declaration of martial law. It is tax fraud to use courts to settle a dispute/controversy which could be settled peacefully outside of or without the court. An official, in parentheses, officer of the court, policeman, etc., must demonstrate that he/she is individually bonded in order to use a summary process. An official who impairs, debauches, voids, or abridges an obligation of contract or the effect of a commercial lien without proper cause becomes a lien debtor, and his/her property becomes forfeited as the pledge to secure the lien. Pound breach, breach of impoundment, and rescue is a felony. What did that just say? Any third-party interlopers want to come in and even talk about my lien or impede it in any way become lien debtors, meaning they now just joined the contract as debtors, meaning they're putting up their property as surety. It is against the law for a judge to summarily remove, dismiss, dissolve, or diminish a commercial lien. Only the lien claimant or a jury can dissolve a commercial lien. Notice to agent is notice to principal. Notice to principal is notice to agent. Public hazard bonding of corporate agents. All officials are required by federal, state, municipal law to provide the name, address, and telephone number of their public hazard and malpractice bonding company and the policy number of the bond, and if required, a copy of the policy describing the bonding coverage of their specific job performance. Failure to provide this information constitutes corporate and limited liability insurance fraud under 15 U.S.C. and is prima facie evidence and grounds to impose a lien upon the official personally to secure their public oath and service of office. So once we've had our affidavit unrebutted for 30 days, the publicly bonded individual, if they're publicly bonded, meaning like a CFO of a corporation, must provide by law the information for their bonding company. No need, you could literally, without ever even walking into a court, levy this process on their bond. Now, if they don't have a bond, you may need to go into a court to get a writ of attachment so that you can bring them into the court and have them deposed, where you get their account numbers, the banks where their accounts are held, where all their properties are, what counties those properties are in. Okay, so the necessary elements of our commercial lien. We've got our maxims, which is our law, parties, allegations, proof of allegations, ledgering. This is all ledgering. And surety. Okay, this is the $3.48 million bond or lien that Winston did. And this ledgering is what all the charges he has against him. It's $10,000 a piece for each item on here, and he's got a mess of them. These allegations, proof of allegations, ledgering. This is all ledgering. And surety. Okay, this is the $3.48 million bond or lien that Winston did. And this ledgering is what all the charges he has against him. It's $10,000 a piece for each item on here, and he's got a mess of them. For affidavit that accompanied your conditional acceptance, the affidavit or statement of facts included in your notice of fault opportunity to cure. Okay, this is where you're going to sum up all those points. And then proof of allegations. This is where you get to attach your original process. Okay, or your affidavit of truth. Proof of allegations is certificate of non-response in the first affidavit, certificate of non-response in the second affidavit. Those 4 elements are proof of all my 9 points. Because unrebutted affidavit is truth in commerce. Now the ledgering, that's why I like to establish what we're going to be ledgering, usually at about the notice of fault opportunity to cure phase of my initial process, so that when it comes down to ledgering, they're also in agreement with the ledgering. Now in this particular case, there was never an establishment of an agreement with the ledgering, and it's not a necessity, because what he's doing is from his 9 points, he's establishing constitutional violations, as he calls them in here. Basically, his all right. So, this particular ledgering, under U.S. code, a constitutional violation has some certain value of $10,000. So, to give you an idea, there were 2 lien debtors in this particular lien, and the 2 lien debtors with all of these constitutional violations at $10,000 a pop came to $3.48 million. Okay? Yeah. No, wait. That'd be 3,004. It'd be, 3,480, but it's probably divided in half because it's multiplied by 2 by the number of lien debtors. So it's probably 1,740 or something like that. Okay. Now, all of these elements are absolutely necessary in the commercial lien. Okay. Maybe not the maxims, but I would include maxims to establish the law of the contract. So maxims, absolutely necessary in my process. Parties, of course, absolutely necessary. You don't name any parties. Allegations, absolutely necessary. Proof of allegations, absolutely necessary. Alleging is absolutely necessary. And last but not least, the surety. Okay? So surety, I'll read you the surety that he has on here. And really, the surety could be private property, bank accounts, public hazard bonds, any of those elements. There are 174 listed Constitution and Bill of Rights violations valued at $10,000 per violation times 2 lien debtors for a total value of this bill of $3,480,000 in functional currency of the United States. The surety / property utilized to guarantee the payment of this commercial lien is the operational / commercial bonds of each of the lien debtors. If the bonds of the lien debtors are insufficient for coverage, the payments, the assets of the lien debtors will be utilized as follows. All the real and movable property and bank and savings accounts and of the lien, I'm sure that and isn't supposed to be there, of the lien debtors except wedding rings, keepsakes, family photographs, diaries, journals, etc., and the property normally exempted in the lien process, including survival provisions. And then, of course, a certification, because it's an affidavit of obligation, some kind of a certification, some kind of a verification. This is I've seen, I think Winston uses this on a lot of his stuff. This is a what he calls a commercial verification. I, Winston Shrout, certify on my own full commercial liability that I've read the above affidavit and do know the contents to be true, correct, and complete, and not misleading, the truth, the whole truth, and nothing but the truth, and do believe that the above described acts have been committed contrary to law. Now, he had to include that little clause in there about being contrary to law because he's actually in his allegations got criminal offenses. And on his ledgering, criminal offenses. So that particular clause right there, and do believe that the above described acts have been committed contrary to law, only necessary if there's criminal acts, okay? Not something you would include if it's based on contract, okay? And you're not basing it on any criminal violations of any kind. You're just basing it on breach of contract or something along those lines. Okay, so that was step 2. And of course, with that, you would include proof of mailing and contents mailed, and you would do a certificate of non-response on that as well. Step 3 for this particular process, notice of fault, opportunity to cure. And again, parties named, affidavit of obligation, commercial lien mentioned, verification on it, statement of facts, and here I'll show you the statement of facts that he's got on this particular one. Only 4 points. On or about 1/25/2001, John Smith, lien debtor, and Bill Brown, doing business as Mayor, City of Ivins, lien debtor, received service of affidavit of obligation, commercial lien. Point number 1. Point number 2, neither John Smith, lien debtor, nor Bill Brown, doing business as Mayor, City of Ivins, lien debtor, as of the 19th of June, 2001, has responded to the affidavit of obligation, commercial lien, nor affected the remedy. Number 3, John Smith, lien debtor, and Bill Brown, DBA Mayor, City of Ivins, lien debtor, are at fault. And number 4, As an operation of law, lien debtors, by dishonor of affidavit of obligation, commercial lien, have created a fault. Next little section, opportunity to cure. In the event that lien debtor's failure to take the remedy offered in affidavit of obligation, or to take the remedy, was an oversight, mistake, or otherwise unintentional, Jim Jones, lien claimant, grants lien debtors 3 days exclusive of the day of receipt to cure the fault and effect the remedy. Only 3 days. Failure to cure will constitute, as an operational law, the final admission of the obligation by lien debtors through a tacit procuration to the affidavit of obligation, commercial lien, and the whole matter shall be deemed res judicata and stare decisis. What does that mean? Stands on its own, stands as a judgment. Response by lien debtor must be served on Jim Jones, lien claimant exactly provided. He has the address of a notary, again, because the notary is going to certify the non-response to the notice of fault. Jim Jones, lien claimant, awaits lien debtor's timely response. And again, would be included with affidavit of mailing, contents mailed, and be followed up by your certificate of non-response. Okay. Those documents, the affidavit of truth, proof of contents mailed, proof of mailing and contents mailed, the affidavit of obligation, and the certificate of non-response for the affidavit of truth, the affidavit of obligation, commercial lien, along with proof of mailing, contents mailed, and certificate of non-response, along with notice of fault. Remember, you're keeping the originals on all these because they're statements of fact, affidavits, right? You want the original signature documents. In all, it's going to be one big security. And then the last and final step, notice of default, a proof of mailing of it. And notice of default, same commercial verification on the front, statement of facts, on or about such and such a date, John Smith, lien debtor, and Bill Brown, lien debtor, received service of a notice of fault, opportunity to cure. Number 2, neither lien debtors as of the such and such a date has responded to the notice of fault, opportunity to cure, nor affected remedy. And number 3, John Smith, lien debtor, and Bill Brown, lien debtor, are in default. By the terms and conditions of the preceding lien and notice of fault, you are under obligation to timely and in good faith respond or make proper answer with proof of your claim. Your failure to do so is a dishonor and places you at default. By your default, you are deemed to be in bad faith, violation of public trust, bond, and or ministerial duty to do that which is right, that you have instanter waived, yielded up any claim to your original claim. I don't know what that is, or if maybe it's spelled wrong, or maybe my own lack of vocabulary has me at a block there. But this matter is stare decisis and res judicata, and lien debtors are in estoppel by their failure to respond. This process, complete in and of itself, is a judgment. Somebody took one of these and filed it into the district court. District court clerk sent it back to him and says, you already have judgment. What do you want us to do? Why? You've got a judgment. That's what the clerk was telling him. You've got a judgment. You don't need a judgment from us. Now, if you wanted to use this to get a writ of attachment, what are you doing? You're amending an already existing judgment. Okay? So, If you don't,
The sheriff is also, obviously they're going to refuse it because it's not.
they're going to refuse it? No, they're not. They're going to refuse what? A writ of attachment?
No, it's before that. I mean, you have a pretty leading process. It doesn't.
Right. Remember, my affidavit of obligation makes it a security with the tracer flag on it. I could take this document, file it on a UCC1 financing statement, or actually file a UCC1 financing statement based on this document. I'm the secured party. Bill Brown and Jim Jones are the debtors, right? List the collateral as their bonds, their private property. If they have property in the county, list it there, right?
Basically, for example, if it's a lien against the CFO, but you can have bank.
Yeah. Yes, he said you could put a lien on the CFO of IndyMac Bank. Yes, you could. If you did this process with the CFO of IndyMac Bank and they didn't respond all the way through to your judgment, then you could file the lien against them. The fact is, you've got the lien. What is a UCC1 financing statement? A notice of lien. Remember I told you don't ever file those things unless you have something to back it up. This is that thing. This backs up that UCC1 financing statement. This, along with your UCC1, after 90 days, anyone can collect on it. You can sell it to a collection agency. It's a security, and it's got a public notice of it. You can do an assignment of this security on the UCC3, an assignment to a new secured party. So I can sell it to Walmart, unless they're the lien debtor. And actually, they may want to buy it at a discount.
Does that become a negotiable instrument then?
Yes, well, not in and of itself. A negotiable instrument like a documentary draft can be used on this document. So for instance, I could do a bill of exchange or a documentary draft on this claim because this claim is attached to their bond. So basically, they must provide their bondholder information if they're bonded. If they're a CFO, they're bonded. They have to be. They're an officer of a public corporation. They must be bonded, which is, maybe some form of insurance or something like that. But the fact is, they're bonded. They must, by law, provide the information of their bonding. Now, what if they resist? They can break the law. I could file an order to show cause. That's it. Go into district court, order to show cause why the lien debtors should not supply all their personal account information, their bonding information, and information on all the properties that they hold. Can they show cause why they shouldn't? Considering they had how many opportunities to rebut your process? Let's get our microphones going. We can pass that. We have one in the back. I'll hand him the other one. Can you hand that back? Thanks.
Brandon.
Yes.
Is there any reason why, in the case you just went through, why they did not respond or would not respond in time to keep this from progressing on to the judgment?
Well, because they have to respond by affidavit. Yeah, what are they going to do? Lie? And now, that's actually a good point. Don't ever lie on your affidavits. You want to see commercial death? Lie on your commercial affidavit. And you'll never operate in commerce quite the same if you operate in commerce at all. Except for maybe being a warehouse item. Okay, so don't ever lie on your affidavits. use only your established facts. Okay? You can make mistakes, but if you become conscious of a mistake, you must correct the mistake. Okay? But again, that's why so much care and focus must be put on any of these documents that you put together. Okay? Go ahead.
Could you take the completed forms and take it to a bank for a letter of credit?
Yeah,
That's one way of liquidating itself then.
yeah. Yep, with that tracer flag on there, literally the bank would also probably, you'd be able to do documentary drafts with the bank. If you're putting the actual security on deposit with them. Yeah. Can we get a microphone over here?
Testing 1, 2, 3. Testing. Well, I hope you guys learned something today. 0 viewers. Oh no. Some heavy stuff, but here's some notes that I got here. So let's see. Let's start here. Okay. Affidavit of Truth. Also breach of contract. So if you have a contract with somebody, they breached it, I need to explicitly state the surety. So sureties is basically like if they're bonded or if they have private property. That's the surety. And then executing levy. So that is this is the first step of your affidavit of truth. And so this is a levy. So this is you're basically justifying your right to lien if they fail to respond. As well, you need to have an affidavit of a witness, preferably a third party who is not the beneficiary of this process, to witness the non-response and the mailing of the original affidavit, and then the mailing of the certificate of non-response as well too. And then they also have to submit an affidavit as well too. Preferably somebody of good character, because probably they might go after that person if you were to do it. So yeah, that's the first one there. Affidavit of Obligation. So this is after there's no response. So he's talking about like a tracer flag, like something to legitimize it as a security of some sorts, depending upon which country you are in. Establish the laws of the contract. And then we can go into that. So foundation commercial law is truth. Truth is sovereign. Unrebutted affidavit is a truth in commerce. So if a statement of fact, when remedy doesn't exist, this process can be used as a levy against the parties, accused parties. Ignorance of the law may be an excuse, but when commission of a crime is being committed, when the law is easily available, there's no excuse. Government commercial liens, contracts. Oh, what's this? Governments can't abide by commercial liens and contracts. They don't have any jurisdiction to interrupt in the liens. If they do, they become a lien debtor. So if a judge tries to impede, or any other third party tries to impede, they can become a lien debtor. Legitimate corporate bond. So if they have if they're a public servant, they more than likely have a bond or some sort of insurance that you can add as a surety. And then he was also talking about if they don't want to, they have to do this by law. If they don't want to do this, they have to have a valid reason as to why they shouldn't, and that'll put them in a bind. So they can't ignore you that way. It's tax fraud to bring controversy to the court when a dispute can be settled outside. Go with the surety bond company, and then and then the third step. So basically, oh yeah, make sure you have the ledger. Mentioned about the ledger, the proof of allegation. So that would be your original statement, affidavit. Put the maximums on there. Notice of default, and then ledgering all the damages that have been done. And then also I'll put on here writ of attachment to deposed. So when you depose, it's actually a crime if they. So that's talking about the bonded. So if you depose them and they deny that, they can get into a lot of trouble. So there's also that too. Okay, so that's basically the gist of it. And then he went into a little bit about the notice of default. So yeah, so you make sure you have the original copies to send in as all at once. Notice of default is basically the last thing you send to them, and then you just have the statement of fact of what happened. You give them a chance to cure within 3 days, of course. If they don't cure, then it is officially defaulted, and then you can basically submit your lien into a bank or sell it to a collections agency. You can go after their private property, you can go after their bond, you can go after public buildings, stuff like that. So, yeah, that's just basically the gist of it. I hope that was educational and you find a use of it. And I hope you guys have a good rest of your night and peace out.